In March 2025, Trump didn't just sign a document, he dropped a political bomb. With one stroke of the pen, he accused legal giant 𝐼 of unfair hiring and banned their employees from setting foot in federal buildings. No clearances, no contracts, no access. Just like that. Erased. And the reason? Their commitment to diversity. This wasn't policy, it was a purge. And it sent shockwaves through every law office in Washington. Now let's unpack that for a second. Think about the scale of that. This wasn't just about policy disagreements. No, 𝐼 was being singled out, and not just for their hiring principles, but for their so-called political activities. And what were those activities? Well, maybe it's because they represented Hillary Clinton during the 2016 election, or maybe it's because they've been involved in litigation, calling out practices and policies tied to Trump himself. It's not a leap to see some, let's call it, personal resentment fueling this decision. Mark Zaid, a national security attorney, talks about a federal judge's ruling that Trump's executive order targeting the law firm 𝐼 is unconstitutional, likening it to a Shakespearean character intent on being king. In Shakespeare's play, Henry VI, Part 2, Act 4, Scene 2. The quote, "The first thing we do, let's kill all the lawyers," is often misinterpreted as a criticism of lawyers. Within the context of Shakespeare's play, it suggests that the rebels see attorneys and the legal system as obstacles to their goal of overthrowing the government. A breakdown in law and order is essential for establishing a tyrannical regime.
Order targeting a law firm is unconstitutional. The executive order issued in March tried to seek retribution against the law firm 𝐼, who represented Trump's 2016 presidential opponent, Hillary Clinton. The judge wrote, "No American president has issued an executive order like the one at issue in this lawsuit." And likened the order to a Shakespearean character intent on being king who coined the phrase, "The first thing we do, let's kill all the lawyers." Writing, with this executive order, the Trump administration is, quote, "sending a clear message. Lawyers must stick to the party line or else." Joining me now is Mark Zaid, a national security attorney who represented government employees and whistleblowers in the past and has been targeted by this very administration. Mark, good to see you, my friend. You've been targeted, as I've said, by the administration for clients you have represented. How do you feel tonight after seeing this ruling?
Very vindicated, and I'm not surprised that the rule of law prevailed in this particular case. I mean, this was an incredibly overbroad executive order. Just to put it in context, it suspended, I had my clearance revoked, it suspended the clearances of everyone in the law firm, regardless of what they might have ever worked on or not. In fact, some of the lawyers who had their clearances ostensibly suspended did not have a clearance because they were lawyers. They had it because they were in the military, in the Guard, in the reserves. So what did they do to be punished in that way and to, of course, be banned from federal courts? I mean, it was obviously purely retaliatory and vindictive. And one of the things the judge pointed out was, in fact, that the law firms who capitulated and took the deal, that all of a sudden they went from being untrustworthy and a threat to national security, but because they made a deal with the administration, they can have their clearances back.
So what should law firms be doing? I mean, obviously, this judge gave a scathing rebuke. There's been a lot of opinions about this. You had Supreme Court Justice Ketanji Brown Jackson, in fact, talking about more broadly judges being targeted as well. What should law firms be doing in light of what's happening?
They should be standing up for the rule of law, right? We are not necessarily our clients. Look, there are lawyers on both sides, many sides of the ideological aisles who maybe do push particular causes because that's what they believe in. Most of us, I'm sure everyone is influenced in some way, but most of us, we're representing the client's interests, right? I don't think the ACLU believed the Nazi propaganda that clients were espousing back in Skokie, Illinois in the late 1970s. It was standing up for the rule of law. And it very much was the quote from Shakespeare that Judge Howell mentioned, which I've mentioned on your show before, about Dick the Butcher, because the notion was we always think that this is a negative towards lawyer. It was a Shakespearean compliment, because the lawyers were preventing an authoritarian dictator from coming into power, because that's what we do.
I want to highlight what was said by this judge who had opinions of the law firms that Trump was targeting. She writes,
this executive order wasn't about mitigating national security risks, despite what the administration claimed. It was about sending a message. You represent the wrong side, you challenge us, and you'll pay the price. None of this is normal. Not for democracy, not for our judicial system. If anything, it feels like an attempt to blur the lines between political feuds and the impartial role that legal professionals play in our society. It's something that would have felt unthinkable a few years ago, but here we are in 2025. And these executive actions didn't just rattle Perkins-Coie. They sent shock waves through the legal community. Imagine being a lawyer or a firm watching this play out, knowing that standing up to power could have consequences that go beyond the courtroom. Chilling, isn't it? You see, this executive order isn't just about one firm. It's a statement, a clear one, about how far a president might be willing to go to rebalance the scales in their favor. And the question that lingers is, where do we draw the line? Because if one firm can be punished for simply standing on principles or representing a disliked client, who's next? All right, so let's break down Judge Beryl Howell's scathing response to this unprecedented executive order. Her 102-page ruling didn't just block Trump's order, it dismantled it entirely. Howell found that the order violated the First, Fifth, and Sixth Amendments of the Constitution. And that's big, because think about it. The First Amendment protects free speech, right? Yet here was a firm being punished for representing clients whose causes didn't align with the Trump administration's views. That's, well, textbook retaliation against protected speech. And then there's the Fifth Amendment, which guarantees due process. Howell noted how the execution of this order was so vague, so slapdash, it left Perkins-Coie and even his clients in limbo. No proper warnings, no balanced legal process, just directives coming down like a hammer. No room for transparency or pushback. But here's the kicker. The Sixth Amendment also came into play. Now, you know this one. It's all about the right to choose your own legal counsel, no matter how unpopular the case or the client. Howell pointed out that this order was forcing clients to walk away from their chosen lawyers or risk being punished through federal pressure. It's hard to imagine a clearer case of undermining people's basic legal rights. One part of Howell's ruling that really stuck with me was her reference to Shakespeare. You know, the infamous "kill all the lawyers" line. She essentially reframed this phrase for 2025 politics, describing the executive order as an attempt to, quote, "kill the lawyers I don't like." It doesn't get much more unvarnished than that. And let's be honest, Howell's decision wasn't just about righting constitutional wrongs. It was sending a message to law firms everywhere. A message that, yes, lawyers have the right and the responsibility to challenge power. That they shouldn't have to weigh the risk to their careers or their reputations when they take on politically sensitive clients. But beyond that, it reaffirmed the fundamental principle that the law cannot be bent to serve political vendettas. This ruling, it was a victory for the independence of the judiciary, a reminder that the legal profession's integrity isn't optional. Howell didn't mince words, saying these kinds of actions endanger the role lawyers play in safeguarding justice itself. Now, let's talk about the aftermath of this historic ruling. The ripple effects from Judge Howell's decision go far beyond the Perkins-Coie case. For one, it sent a resounding warning to other law firms. Some of them, seeing what was happening, opted to settle with the Trump administration long before this reached the courts. These firms made deals, offering millions of dollars in pro bono work to causes the administration supported. And honestly, who could blame them? The threat of losing federal contracts or being locked out of government buildings is no small thing. But here's the flip side. Firms like Jenner Block and Sussman Godfrey didn't back down. They filed their lawsuits and won temporary blocks on similar orders targeting them. Judge Howell's ruling isn't just a win for Perkins-Coie, it's a legal precedent. It establishes that these executive orders dripping with retaliation and overreach won't hold up when they're challenged by the courts. And let's not forget what this case has meant in terms of precedent. A safeguard against executive overreach in politically sensitive disputes. This isn't just about a president targeting lawyers. It's about protecting the fundamental constitutional rights we all depend on: free speech, due process, and having an attorney who can stand by your side no matter how controversial your case may be. I must tell you, cases like this remind me why democracy is so fragile but so worth fighting for. It takes effort, commitment. Back in my own grassroots advocacy work, I've seen firsthand how systems of power often move to silence dissent. Whether it was advocating for equitable healthcare access or tackling local corruption, the stand is never easy. But is it ever necessary? This ruling, it's proof that even when power tries to tip the scales, when fear and retaliation come into play, there are systems in place to pull us back from the brink. Democracy doesn't survive on autopilot, folks. It survives because people like Judge Howell, like those law firms that refuse to back down, choose to stand firm even when it gets uncomfortable. And with that, we come to the close of today's deep dive into one of the most telling lawsuits of our time. I mean, think about everything we've unpacked here. How a single executive order set off a cascade of legal and constitutional challenges that forced us to confront what democracy truly means in practice. You know, these aren't just headlines. They're moments that remind us of what's at stake when power is misused and how vital it is for all of us to stay engaged, whether it's in law, medicine, or policy. If you've tuned in and found this as gripping as I think you did, I'd love to hear your thoughts. What do cases like this signify to you? How do they shape the story of our democracy? Reach out, send an email, join the discussion on social media, or even leave a comment on Spotify or Substack. And don't forget, you can always count on the Real 411 to bring you the facts behind the noise. Now, before I let you go, let me leave you with this. Democracy isn't just a system. It's a commitment to advocate, to question, and yes, sometimes to fight for what's right. Stay informed, stay bold, and as always, stay real. Thanks for listening, and I'll catch you on the next episode of The Real 411.